Good morning, everybody, and welcome to the webinar. We're given maybe it is 9 o'clock, and I think let's get started. We have a lot of speakers, and we need to get through everybody within the time provided. This morning, we're talking about the role of project management team in construction projects. Those of the attendees who came to our directors webinar last year when we discussed risk on construction projects. Today we've got our fabulous team of senior associates and associates within the construction engineering sector who are going to take you through and deal with the topic and give you more insight into the role of the project team on the project professional team on construction projects. In particular, we'll look at overview, we'll look at risk allocation, we'll look at the functions of those professionals within the standard form of contract that are used in the industry generally in South Africa, such as the JBCC and FIDIC forms of contract. So please, I've got limited time. I will leave the individual speakers to introduce themselves, but please go through to our website. All of the speakers are on the website. Their profiles are there, and to get to know them a bit better. If you've got any questions, please raise them, put them in the chat box. We may not get time for a question and answer session, but any questions that have been raised, we'll formally respond to them at the end or after the webinar. So I think let's get started. Our first speaker, Kanaleno, he's going to tell us why the project team is so important on a construction project and a bit about what the professional team constitutes. Kanaleno, over to you.
Good morning, everyone. My name is Kananelo Sikakane. I'm an associate in CDH's construction litigation team, and I'll be discussing what a project team is and why it is so important. Basically, the project team in construction projects is responsible for the planning, designing, executing, and managing of the entire project from inception to completion. It is the project. It typically consists of a diverse team of experts made up of a design team and a building team. The design team is normally the architects who develop the project, engineers who oversee the technical aspects of the project like material selection, mechanical and electrical installations, and ensuring compliance with the building standards of South Africa. On the other hand, you get the building team, which is the general contractor who attends to the actual construction works, and the project managers, site superintendents, and safety officers who collaborate with the contractor to ensure that the project is completed on schedule, within budget, and to the required quality standards. Now, the importance of the project team is patent in its definition. They are the project, They attend to the designing of what's going to be built, and then they build it. And the national construction industry in South Africa grapples with a number of disruptions to projects. Riots, construction mafia interference, and sometimes a lack of funds, right? Really derail projects. But it has been shown that major projects in South Africa are still being derailed by the same old set of failures, and the majority of these sets of failures are linked to the project team. The Crux Insight report did an analysis of the top 10 causes of disputes globally on construction contracts. And these 10 causes are a change in scope, incorrect design, design information being issued too late or being incomplete, poor contract management, poor management of subcontractors, contract interpretation issues, workmanship deficiencies, restricted or late access to site, and unforeseen physical conditions experienced on site. Now, interestingly, the Crux Insight report also showed that specific to Africa, the three main causes of disputes are a change in scope, restricted access to site, and design-related issues. Now, that's either the design being issued too late or being incorrect or the design not being met. These three issues alone led to long overrun claims in 38% of the projects initiated in Africa. Right? And these three disputes led to a 76% extension of time on the project and a 59% increment in costs. So it costs time and money if you don't get the project team right. And this is why it is important to appoint the right project team with the proper expertise and ensure that the contracts related to the project are properly drafted. My key takeaway for anyone listening is that a lot of people focus on the contractor. You know, it's always said that we need to get the right contractor on board. But it is important to ensure that the project team is seen as what it is. It is a unit that is made up of a design team and a building team. And we must make sure that that unit is strong, from the architect to the engineer, to the contractor, to the project manager, and even to the site superintendent. And we need to actually make sure that we can actually see that in the majority of the claims that are instituted in Africa, a lot of the issues are caused by design-related issues. Therefore, every stakeholder in a project must invest in the early and thorough design development and ensure that you rebalance the risk allocation in all contracts in order to avoid excessive risk. My colleague Zippo will take you through how you do exactly that. Thank you.
Great, thanks, Carolina. Yeah, this goes back to what to call the pyramid in construction: quality, time, and money, and getting that balance right, and making sure, if you look at each one of those, there are professionals involved in guiding that process as to the quality of the work, the money, making sure that you remain within a budget, and your planners making sure the time and the project is met on time. That risk allocation and getting involved right in the beginning and getting advice on that risk allocation. Sifo is going to take us through that and his insights into that risk allocation. Thanks, Sifo.
Thanks, Clive. A very good morning to everyone. I am Zippo Dile, an senior associate in the banking projects and infrastructure team. I hope that at the end of, within the next 10 minutes, I can charge us to approach risk allocation and contract negotiation very conservatively and carefully. The work that we have received recently within our team from an infrastructure construction perspective spans from renewable energy, which is obviously what has been on the mainstream. And now recently we've seen water infrastructure. We've also seen interesting projects where there's proposed construction of towers. And we're working on a gas to power project, infrastructure project. And the reason why I'm mentioning these different types of projects is to give you a sense of the differences in the technologies of these projects. And as you can imagine, the way these projects are financed is different. Therefore, the risk profile for each project will differ from one project to the next, which then links closely to the subject that I'm covering, which is how we approach risk allocation when negotiating and drafting construction contracts. Risk allocation speaks to the balancing of the commercial and legal interests as between the parties involved in the project. In the renewable space, you hear the word bankability, and the idea there is your project bankable? Is it acceptable to the lenders? Not just the lenders. There's also a technical question from a technical perspective. Is your project fundable? Is it bankable from a technical and a legal perspective, as well as a commercial perspective based on what the applicable financial model? So in introducing the subject this way, I'm hoping that we can get an in-depth appreciation that where there's a difference in how a project is funded, or a difference in how the technology of the project is applicable, then it would mean that the risk allocation or the approach to how you draft and negotiate contracts is not a one-size-fits-all. So we need to be careful about using precedents. Yes, they are well established in the markets. We have standardized forms of contracts and each useful for its intended purpose. But even within those circumstances, we need to be circumspect as to what are the specific risks that are inherent in a particular project or technology. Okay. To kick off today, I think there are a number of risks that are foreseeable in projects, but I'm going to pick on 3 risks which I think are big subjects. And my thinking is in this wise: if you can build a project on time, if you can build it to a specific standard of performance that is expected, if you can complete within budget, then you have delivered a successful project. So time, quality, and cost, if you can pin those three things down and deliver within the time, within the cost, and within the quality, then no doubt you've delivered a successful project. Obviously, there are other risks. There could be design risks, which could appear as a latent defect in the future, even if you've delivered on time, within quality, or within cost. At completion, those things could come up later. So I'm just saying I'm dealing with these three: time, cost, and quality. So in thinking of risk allocation, it's about allocating risk to the party best capable to allocate that risk. And if there's a risk, it's the process of identifying the risk, analyzing the risk, allocating to the appropriate party, and mitigating that risk. It's a process that you do on the front end. It's not something that you wait to fix down the line when there's a dispute. It becomes apparent during disputes that at times careful attention to detail in drafting contracts and negotiation wasn't done in the upfront. So I'm trying to charge us again to think carefully about conservatively about how we approach contract drafting. Let's briefly then talk about time, quality, and cost. When you talk of time, quality, and cost, there are many things that could impact on time, quality, and cost, and some of them are weather, force majeure, unexpected site conditions, change in the scope of work, change in law, defects defects to the infrastructure, interruptions on site. In South Africa, we were on a site recently, and guys walked in. Tall guys who looked like bouncers walked into the site, and alas, it's the mafia. But anyway, we came out unscathed. But the point I'm making is there are many things that could impact a project, and the risk will differ from one project to the next, depending on funding, depending on the technology, depending on the complexity of the project. When it comes to managing time, I want to say that when we negotiate contracts, we should be careful about the provisions that entitle the contractor to have an extension of time. We should limit the grounds for which there could be an extension of time for completion, because you want to complete your project on time, and only allow for an extension of time for contractor-caused delays to completion. But for employer-caused delays to completion. But when it's a contractor delay event, then you shouldn't give an extension of time. You should be very conservative in doing so. You should avoid those circumstances. But there are certainly circumstances where you can't regulate upfront as to whether you can grant an extension of time, and those become negotiable, and you'll use your disputes mechanism, therefore an independent expert, to make a determination as to whether or not we should grant an extension of time. So we should be very careful about extension of time clauses. Secondly, when it comes to mitigating your time, therefore completing on time, you need to size your liquidated damages appropriately. Liquidated damages are not penalties, strictly speaking. Liquidated damages should be sized, or intended to be sized, to cover income lost because the project has not been completed on time. Secondly, it should cover the increase in costs, because if you don't finish on time, then there's an increase in your cost. The idea with LDs is that if you don't have a robust liquidated damages regime, you don't complete on time, that liability will fall onto the employer, and you want to avoid that. You want to push it down to the contractor, make sure that he's incentivized to complete on time. The second one that I will touch on briefly is quality. Quality has to do with performance. And when it comes to performance, we ought to be very strict in how we define what the scope of work is. Define it very clearly. It will vary from project to project. Don't approach a one-size-fits-all approach. When it comes to disputes, these things emerge and they become apparent. We should define what the scope is. We should be very careful to define what the testing procedure is for the quality or the performance standards. Your performance guarantees must be set out very clearly in the construction contract. And finally, let me deal with cost. I think hopefully I still have time, Clive. But in terms of costs, there are different types of cost mechanism. It could be the project could be lump sum, it could be cost plus, it could be pay and gain. But in negotiating cost, we should limit circumstances that could entitle the contractor to a cost adjustment or a change in the price of the contract. Therefore, it should be limited to circumstances where there are variations, cost majeure, and change in law. Those three: variations, cost majeure, force majeure, and change in law. And as well as we should set out our milestone payment mechanism in the construction document carefully to align with the finance documents. Your drawdowns under your finance documents must be aligned with your milestone payments. And in closing, the idea for my section of this was just to charge us to think carefully about how we negotiate and be very conservative when it comes to these contracts. It's not a one size fits all. You may understand one type of contract, but that type of contract may not necessarily be suitable for any other infrastructure project. So we should be conservative. We should consult early. We should talk to our lawyers. We should talk to our professional team. We should get our advice and do our allocations appropriately. Again, allocations are not just a legal question. They are technical, they are legal, they are commercial. Therefore, you've got finance, you've got engineering, and you've got legal. All these three must come together and have a solid risk allocation when it comes to negotiating contracts. I will stop there. Great allocation makes for successful projects, and clear drafting, careful attention to detail, appropriate, sound commercial documents are great for projects. I will stop here. It's a wide subject, but I'm going to stop here. Thanks very much, Clive.
Great, thank you very much, Sifo. It is a wide subject and it's and topic, and it's one of those that perhaps you would even have a webinar on itself. But again, it's the importance is getting your entire teams up front when you're going to do a project. You know, one strategy isn't always the right strategy to say, I'm going to then allocate all risk to my professional team, to my contractors. What does the project require? And getting everybody up front to deal with it, be a holistic approach to making sure that you get the best contract so that everybody's working together to have a successful project. What we'll move on to now is the specific contracts. As say, JBCC contract and the FIDIC forms of contract are widely used in the South African market. And to have a look at what the project team and the professionals and their functions are within the JBCC project, I'm going to hand over to Eva. Thanks, Eva.
Thank you, Clive, and good morning, everyone. My name is Eva Babai, and I'm an associate in the Construction Litigation Department. And today I'll be mainly focusing on the 2018 edition of the JBCC. So the project team will primarily comprise of the principal agent and other professional consultants that are engaged on the project. The principal agent is oftentimes an architect or an engineer and is appointed by the employer to oversee the administration of the contract and to act on the client's behalf throughout the project lifecycle. And this team is essential in ensuring that the project progresses efficiently, that it remains within the approved budget, and it adheres to all required specifications and standards. So their coordination and oversight actually help mitigate risks and resolve disputes and drive the project toward a successful completion. Other consultants, such as your architects, your engineers and quantity surveyors, actually bring their specialized expertise to the project and each play a critical role in its success. From a design perspective, you'll see that the architect and the engineers are responsible for developing and refining the project design, in preparing detailed specifications and ensuring a full compliance with the applicable codes and regulations. In terms of cost management, quantity surveyors are essential in controlling the costs. They provide accurate cost estimates, they manage the financial reporting, and handle variations throughout the project's life cycle. So when it comes to progress monitoring, each consultant oversees their specific scope of work, tracking performance and reporting back to the principal agent to ensure that there's an alignment with the project goals. As the employer's appointed representative, though, the principal agent carries significant duties. But it's important to remember that a principal agent is not empowered to alter the agreement itself. So I've divided some of the important things that principal agents are obligated to do and responsible for. So the first one is managing communication and documentation. As the principal agent, you are the central hub for all project communication. So you're there to ensure that all notices are given and received correctly. You're there to ensure that you timelessly provide any construction information to the contractor. You record, you distribute minutes of meetings that are held with the contractor to track progress and manage technical and coordination issues. The principal agent is allowed to delegate its authority to issue instructions. However, the contractor actually needs to be notified of the delegation. This ensures clarity and prevents confusion as to who has the power to issue instructions on behalf of the employer. The delegation allows for specialized expertise to be brought in for specific tasks and ensuring that instructions are given by individuals with the relevant expertise. So can these powers that are delegated be subdelegated? The answer is yes. However, that agent must do so with the written consent of the employer, and notice must be given to the contractor. The second part that is very important for principal agent is overseeing financial administration. Your role is financial oversight and certification. You're responsible for issuing payment certificates at a regular agreed upon interval to the contractor right up until final payment certificate. With each payment certificate, the principal agent must issue a recovery statement with amounts owing to the employer or the contractor. So should you fail to actually perform these duties by the due date, the contractor may suspend the works or terminate the agreement. And you can imagine what an utter disaster that would be for the employer because it impacts the practical completion date. When it comes to adjustment of the contract value and the final account, the principal agent determines the value of adjustments to the contract value together with the contractor in preparation for the final account. The principal agent is required to exercise a fair and reasonable judgment by making fair assessment of the claim and adjusting the contract value. So should the agreement be terminated, the principal agent is actually still required to certify the value of the works that have been executed and the materials and goods for payment by the employer or contractor until such time that the final payment certificate is issued. This would include the cost of materials and goods and those ordered before termination. The third point is that as a principal agent, you're there to guide the execution and works management. You ensure the physical progress and the quality of the works. So you must inspect the works within the period stipulated in the contract data. You then issue a certificate for practical completion. The practical completion certificate will be issued where the works have been completed in accordance with the specifications and the works do not have patent defects. However, minor defects need to be identified by the principal agent in a list for practical completion. So where the works have not reached practical completion, that would be where the works have a patent defect. The principal agent needs to issue a comprehensive and conclusive list for practical completion, detailing the defects that the contractor is required to remedy. It's conclusive and comprehensive, meaning that you cannot add to it or update it once it has been issued to the contractor. But one way you can remedy it, if you're a principal agent and you notice that you might have missed something out, is that you can issue a contract instruction for repair work. Other agents are empowered to assist with the inspection of the works, but it's important to note that the certificate for practical completion is the sole responsibility of the principal agent. There are consequences, of course, if the principal agent does not fulfill their duties under the agreement. And there's a deeming provision in the JBCC. So if you inspect the works, you are required to, within 5 working days, then issue the the list or practical completion. And should you not do so, and the contractor notifies you, and that notification expires, the practical completion will be deemed to have occurred upon expiry of such notice. And this will definitely be a tough situation for the employer to be placed in. And the principal agent can actually be held liable in terms of their professional services agreement. The last point that I want to deal with is how you should, as a principal agent, deal with revisions to the date for practical completion. So you need to assess the claims under the agreement for extension of times correctly, but because it has an impact on the completion date as well as compensation that may be payable to the contractor. So when assessing a claim, take note of the time barring provisions, as a contractor may actually forfeit a claim. And the contract tells the principal agent that if they do not assess a claim within a stipulated time frame, the contractor would have the opportunity to submit a notice of disagreement. And this actually notifies the employer that you're not doing your job as the principal agent. I'm going to stop there, Clive. There's a wide array of topics that we could discuss under the JBCC, but thank you very much.
Great. So thank you, Eva. Yeah, it's one of the starting points Carolina mentioned in his presentation. Poor management is one of the biggest reasons for disputes and arising within the African continent, and generally we found that in South Africa as well, hence the webinar we're doing this morning. It's a matter of getting that right professional team in place up front. Merely because an architect does your design doesn't mean they're the best person to be your principal agent, as an example. Making sure that you have somebody who's managing the numbers, managing the program. So very, very important in that regard. There was one question that came up in the chat box, so I'm just going to answer it for the purpose of the audience as well. It says, how would you describe a risk of construction mafia? Most of the JBCC forms of contract is that the force majeure event is things such as civil commotion, disorder, riots, strikes, etc. Whether or not the risk of construction mafia falls into civil commotion or disorder is a debate. And I'm not going to go into any further than that, is that you will find those clauses are being changed drastically in a South African context to try and deal with issues of the so-called construction mafia. So just be careful seeing those clauses if you're contractors and what risk is being allocated to you, or if you're employers or contractors getting advice from your lawyers as to how to deal with that particular issue in your contracts. The second, I'm sorry, Lakina, I've eaten into some of your time, but the second form of contract that's widely used in the South African market is the FIDIC form of contract. So again, what is the professional team? How does the professional team manage a FIDIC contract and their designations within that contract? So Lakine, over to you.
Good morning, everyone. Today, I will be exploring the roles and responsibilities of the project team under a FIDIC contract. Whether you're an engineer, a contractor, or an employer representative, understanding these roles is crucial for successful project delivery. For the purposes of my presentation today, I will be limiting my presentation to the FIDIC Red Book, the second edition 2017. FIDIC is a standard form construction and engineering contract and consists of a suite of contracts tailored to a specific purpose. These contracts are widely used in international construction projects because they offer a balanced framework for managing risk and responsibilities. Each type of contract caters to different project delivery models. The common types of FIDIC contracts are the Red Book, which we will be discussing today, which is for the purpose of construction. The Yellow Book, which is your design and build. Your Silver Book, which is your EPC, a turnkey form of contract. And your Green Book, which is the short form, which is used on smaller types of projects. The FIDIC framework defines clear roles for each stakeholder. The employer initiates the project, the engineer administers the contract, and the contractor executes the work. Supporting roles like subcontractors and consultants also play vital parts in ensuring quality and compliance. So the first stakeholder that we're going to look at today is the employer. The employer is responsible for providing access to the site and ensuring financial arrangements are in place. They appoint the engineer and retain intellectual property rights over contracted documents, which are licensed for use of the project. So if we look at specific clauses in the FIDIC contract, you will see that clause 2.1 provides the employer is responsible for providing access to site and possession. Clause 2.4 ensures that financial arrangements are in place, and the employer may further appoint the engineer or the employer's representative, and the employer further retains IP rights over the contracted documents under license. Now, the next role that we are going to look at in a FIDIC Red Book is the engineer. The engineer is central to contract administration, especially if you're dealing with disputes. The engineer is a key part of resolving any sort of dispute. The engineer issue instructions, approve work, and make determinations. While not impartial, they are expected to act fairly. Delegation to an engineer's representative is common, especially on large projects. Clause 3.7 of the 2017 FIDIC Red Book outlines the engineer's role in making fair and impartial determinations. So this would be clause 3.5 in the older FIDIC Red Books. When the parties disagree on matters such as claims, payments, extensions of time, or interpretations of contract. So the key elements of clause 3.7 are as follows. When a claim or disagreement arises under the contract, the parties cannot resolve it themselves. The engineer must make a determination. This is your clause 3.7 and 3.5 of the older versions. The engineer must consult with both parties to understand their positions. This includes reviewing submissions, evidence, and arguments from both sides. The engineer must act neutrally and fairly, even though the engineer is appointed by the employer. This is often a point in contention with regards to disputes, as how is the engineer supposed to act fairly if they are to all the parties, if they are appointed by the employer. The determination must be based on the contract and the facts presented. The engineer must give notice of the determination within 42 days of receiving the necessary information. The determination is binding unless and until it is revised by an agreement between the parties, a decision by the dispute avoidance / adjudication board, or an arbitral award. So the next key role player in a FIDIC Red Book is the contractor. The contractor is responsible for delivering the works as specified. This includes managing resources, ensuring safety, and complying with instructions. They must also handle subcontractors and maintain progress despite any challenges that may arise. So basically, the contractor is responsible for execution of the works as per the contract specifications. They manage resources, and they manage the subcontractors who are also required to execute their scope according to contract specifications, and they manage site operations. The contractor must further be responsible for quality, safety, and timely delivery of any deadlines. The contractor further has a duty to comply with the engineer's instructions unless it is unsafe or unlawful. The next key player in the game of a FIDIC contract is the project manager. The project manager leads the contractor's team on site. Their role involves planning, organizing, and motivating the team. They ensure compliance with permits and documentation and are key to managing delays and risks. The effective communication is the backbone of successful project delivery. FIDIC emphasizes the importance of regular meetings, the importance of clear documentation, and early warning signs to manage risks. Collaboration between all parties helps avoid disputes and keeps the project on track. It is important to note the important clauses in FIDIC, which is 3.8, which is the duty to host regular meetings and to keep progress updates, and clause 20.2.3 is to keep proper documentation and record keeping. When disputes arise, the engineer first attempts resolution through consultation and determination. If unresolved, the matter can escalate to the dispute avoidance / adjudication board. This structured process helps maintain project momentum. To succeed under a FIDIC contract, teams must understand their roles, maintain documentation, and foster transparency. Proactive risk management and open communication are essential to avoid delays and disputes. In conclusion, FIDIC contracts provide a well-defined structure for project delivery. Success depends on how well each team member understands and fulfills their role. Thank you for listening to me today. I'm very happy to take any questions. You can put it into the chat. I will answer them. Thank you so much.
Great, thank you, Lakeem. Yeah, it's always be aware, those in the marketplace, when you're doing FIDIC contracts, and the engineer playing a pivotal role in having the FIDIC contracts run effectively and efficiently. Just have a look at clauses that are changed to make it the company representative, taking out any responsibility to an independent engineer. And the question raised in that regard by contractors on a regular basis is, how do I then get a fair determination if it's a company actually deciding what amount I'm going to receive or not receive? So always, again, reading your contracts and making sure and seeing whether there's changes in those contracts that can change the risk allocation between a contractor and an employer. We're very fortunate to have our Kenya office on with us today, speakers from our Kenyan office. And for those who don't do any work in Kenya, the audience, you may be surprised to know the JBCC contracts and FIDIC contracts are used in the Kenyan jurisdiction, but there are certain nuances in the use of those contracts. And to take us through that and give us an insight, I'm going to hand over to Eva with an E. Over to you, Eva.
Thank you very much, Clive. Good morning, everyone. My name is Eva Mokami. I'm a senior associate in the dispute resolution department here at CDH Kenya in Nairobi, which also includes the construction and engineering sector. So we'll be highlighting the specific nuances that apply when you are conducting a construction project in partnership with a Kenyan entity or in Kenya. And we'll be looking at the specific legal framework and regulatory framework, and just picking out the unique things that you need to note. And for this, we'll be looking at 3 prongs. We'll be looking at contracting. We'll be looking at compliance and risk management. We'll also be looking at dispute avoidance and resolution. So to begin, I'll look at contracting. And for this, in terms of the project team's role in Kenya, the nuance here is that most of the contracting responsibility is charged to the employer to undertake. This is because you will see as we go along that the most traditional, the most common method of procurement and conducting the construction project is usually charged
to the employer as opposed to the contractor, because we are still building in terms of upskilling with the contractors and undertaking design and build projects and turnkey projects. So you'll note that when you talk about contracting, the employer will be charged with contract initiation, contract negotiation, procurement, and general risk allocation. So when you talk about procurement in Kenya, in terms of construction projects, you'll note that there are three main methods that we will use. We have the traditional method. This is where you have the design and construction phase being kept separate. So this person undertaking the design is different from the person undertaking the construction. And then we also have design and build. This is whereby maybe the contractor will go ahead to design the project and also go ahead and build it. And then we have another method that is on trend at the moment. This is management contracting. And this is whereby you'll see a lot of projects broken down into what we call packages. And then these packages are tendered out to separate contractors. We are seeing an uptake with regard to design and build projects. We have also come across a few management contracting projects, but the nuance here is that the traditional procurement project is the most common one. And this is because we are, as I mentioned, still upskilling. And its popularity also stems from the fact that it offers general greater cost certainty. We'll look at pricing in a few minutes. When we talk about the standard form contracts that are popular in Kenya, we have the JBCC contract, which is similar in spirit to the South African one, but you will note that it has been adopted to suit our regulatory framework, and we'll also discuss the nuances with regard to that. And then we also have the FIDIC suite of contracts, with the most popular one being the FIDIC Red Book. This dovetails off the fact that the traditional procurement method is the most common method being utilized in Kenya. So the preference for the FIDIC Red Book stems from the fact that you have separate parties undertaking the design and then another party coming on to undertake the construction of the project. As I said, we still have a lot to do in terms of upskilling and adopting the design and build contracts and turnkey projects. With regard to the JBCC contract in Kenya, you'll note that the terminology with regard to the project team is slightly different in Kenya. The South African one, if I understand correctly, it uses terms like principal agent and principal consultant. You may not come across that in our JBCC contract here in Kenya. You will have the architect remaining as the contract administrator, although some bespoke contracts will replace this role with a project manager. Now, the nuance here is that if you're a foreign project manager and you may undertake work such as engineering works or quantity surveying, you need to be alive to the fact that you would need a permit in Kenya, either from the engineers board or from the board of quantity surveyors in Kenya. So if you are partnering with a Kenyan entity, you may have to just make sure that the person undertaking this regulated works is the person licensed to do so. We do have project managers, as we've seen in the FIDIC contracts, because we do employ them. But again, just as I said, if you are partnering with a local firm, you just need to be alive to the regulatory framework in Kenya. When we come to public sector projects, there's a nuance here in terms of the Kenyan constitution. You need to know that if you are partnering or undertaking a public project, you need to be aware that you will be bound by national values as espoused in our Constitution of Kenya 2010. These national values that will be relevant to you will be public participation and transparency. So if you are, say, employing direct procurement as your mode of procurement, you need to be alive to the fact that you will be required to undertake public participation. And if you have been in the Kenyan courts, you will know that our courts will enforce any injunction where the public feel that the project it required public participation and the same was not done. You would also require specific documentation. If you are undertaking a public project, you would require the Public Procurement and Asset Disposal Act, which will enforce how you engage the project team. When you talk about pricing models in Kenya, you are going to see that the lump sum or fixed price project pricing model is the most common one in Kenya, and this affects how your risks are allocated. And we've seen a lot of disputes arising based on, say, if you utilize the remeasurement model, and then you maybe negotiate down your price. The Kenyan courts may find that you negotiated it down based on duress or coercion, and will set aside that agreement. So you need to be alive to the fact that if you agree on a fixed price, you may need to stick to that price, basically. Then when we talk about compliance and risk management in Kenya, you just have to be alive to the regulatory framework around Kenya. You have the National Construction Authority Act, which establishes the NCA, that's the National Construction Authority, which is in charge of registration, inspection, and reporting in Kenya. The NCA Act also has the Kenya Building Code 2024. This will include things like zoning laws, safety requirements on the site. So the project team needs to be aware of the standards that are required on each project site. You also have the National Environmental Management Authority. This is based on environmental, it manages the approvals and licensing and audits. So say if you are constructing around a residential area, it determines that maybe you can't construct past 5 p.m. There's noise pollution. Basically, if you are in a residential area, we're also seeing an increase in High Court injunctions being granted by the High Court against constructions that are being deemed disruptive or do not follow the zoning laws. Say if you intend to construct 30 floors next to the airport, NEMA would have something to say about that. And then you have the county government. Specific counties have specific regulations that you need to adhere to, and the Ministry of Public Works, of course, if you're undertaking public works. And the nuance here is this needs to go into your timelines. If your project is timeline sensitive, you need to understand that you may not get this regulatory approvals as and when you need them. So you need to build this into your timeline so that you do not run late, or you do not get into a problem with the residential associations or the regulatory authorities. And then in terms of compliance, the second thing I wanted to point out is proper document management. We are seeing a lot of disputes arising from lack of proper management of documents on the site. We are seeing lack of site diaries, improper record keeping, and as a dispute lawyer, you know, you're charged with proving your claim. So the good news is that we are seeing a lot of tech solutions coming up with regard to ensuring proper documentation on project sites. We've seen apps such as Site Diary, which is specifically for creating daily site logs with weather and workforce and events. It basically captures everything that is relevant on the project site. We've seen Procore, which is a cloud-based application and covers everything from submittals and drawings and site diaries and change orders. We're also seeing growth in terms of Kenyan specific tech solutions such as BuildSmart, which is a Kenyan platform for construction project. It covers everything from accounting, procurement, and record keeping. And we also have a regional solution called ArcDesk Africa, which is a workflow management application with contract administration features tailored for local markets. So if you are undertaking, say, something like a donor-funded project that has specific documentation and compliance requirements and reporting standards, you may need to consider how you're keeping your records. And we'll see when Christine comes in to discuss it, how this then feeds into your dispute. And then finally, on dispute resolution and avoidance and early resolution, we can note the nuance here as that the Kenyan FIDIC and the JBCC contracts have strict notice provisions, and the Kenyan courts will apply these time bars. Say the JBCC contract in Kenya has a 90-day period within which you need to submit your claim to the architect. So if you do not meet the 90 days, the Kenyan courts will find that your claim is time barred. So the project team just has to be alive to that if there is a claim on the project site. And when it comes to dispute resolution, we do have the Construction Payments Adjudication Bill 2025, which seeks to increase better payment flow on the project side. And we are hoping that this is adapted and so that we can have statutory-based adjudication as opposed to contract-based adjudication in Kenya. So my key takeaway here is that we do have some work to do in terms of upskilling for the project team, in terms of contracting, contract management and compliance, and dispute resolution and avoidance. But it's not all gloom, and we are hoping to see some progress in that area. Thank you.
Great, thank you very much, Eva. Again, it's going into doing work in different jurisdictions. Make sure that you get local advice. So if you're any of our attendees, you're intending to do projects or construction work within Kenya, please just get a hold of our Nairobi office. There's a fully fledged and competent construction team that can assist you on any of those aspects. So always, as I say, if you're going into different jurisdictions, make sure that in those jurisdictions you're using local expertise. Our final speaker is Christine, also from our Nairobi office, and she's going to take us through having a look at the role of the project team when disputes arise. Many project managers, principal agents, engineers think that their job is over once the contract has been completed, but that's not necessarily the case. So over to you, Christine.
Thank you, Clive. Good morning, everyone. My name is Christine Mugenyu. I'm a senior associate in the dispute resolution practice in the Kenyan office and part of the construction and engineering sector here at CDH. So I'm going to take you through the role of the project team during a dispute. And if we lived in an ideal world, then we would not have disputes. But you and I know that disputes are part of our lives, and that means that they also crop up in construction projects. So disputes in construction matters are rarely caused by a single incident. Rather, we see that they tend to build up over time, and they are caused because, of course, we have various players as members of the project team. So because of the sheer number of members that we have, disputes are bound to arise. So when disputes or claims arise, it is very important for them to be resolved very quickly because of the consequences of these disputes. We find that especially when you have like a large infrastructure project, any delays or any cost overruns affect entire economies and countries. So the focus of this presentation will be the role of the project team when a dispute is in its early stages, when the dispute is actively being managed, and if the dispute is not neutralized, what is the role of the project team when formal proceedings are then invoked. So before we delve into into this presentation, I would just like us to go through some of the common categories of disputes that we see in construction projects. So some of the major ones that we see are, of course, payment disputes, where we have issues where we have non-payment of payment certificates or the final certificates, or even underpayment of those payment certificates. Then another common category we see are delay and disruption claims, and this could be due to late approvals that are given, could be due to design changes, could also be to site access issues, like what Zippo was talking about, the mafia coming into the construction project and disrupting. So some of these are the claims that we see. Then we also have another common category is variation disputes, where we have an employer who, for example, changes the scope, the previous scope. So you could see disagreements over the additional works that now the contractor has to undertake and the valuation of these works. Then another major common category is defective works, which goes to the quality of the works, and having works that are done that are not compliant with the contractual framework that has been agreed upon by the parties. Then finally, we have termination-related disputes, which may arise from alleged breaches by various players in the project team, and also could be because of an insolvency event that may affect the contractor who is undertaking the project. So as we have seen, these disputes can be triggered by different parties, and depending on the party, either you're the contractor or you're the employer, or even sometimes you find that consultants and subcontractors actually contribute to these disputes, especially where the dispute is related maybe to their instructions or their scope of work. So with this context in mind, I want to structure the presentation in terms of what the project team should do in various phases. And of course, the first phase, as even Lakin was giving his presentation, he talked about how the FIDIC contracts, the Red Book, is structured in a way that you're supposed to identify early warning signs before a dispute arises. So I want us to look at what is the role of the project team during these early stages, and how can they prevent the escalation of a dispute. So one of the things which also Eva has talked about is documentation and record keeping. We see that there are many documents that are shared between the various persons who make up the professional team. So here we are talking about meeting minutes, site diaries, test reports, variation orders, and all of these documents need to be documented. They need to be in writing, they need to be accurate, they need to be dated, and they also need to be stored in an organized manner. And now what we are seeing is that project teams are now embracing technology. As Eva has shared in her presentation, they are embracing IT solutions and having data rooms where they can be able to share this information and also store this information because of the volume of documents and information that is shared between these parties, especially in big infrastructure projects. So in our experience, when we have dealt with or we have had matters that have escalated to arbitrations or litigations, we have seen that the side that has the better records is often the one that has a stronger case. So this is a key or a crucial thing that the project team must always be alive to when they are taking out their duties in the construction project. Then also another key thing is communication protocols. How is the communication being handled between the team? Is the communication is it in writing? Is it formal? And we find that key instructions that are given in the construction project should be in writing and should be shared within the teams after, of course, having discussions and agreeing. And this also helps to prevent any misunderstandings in the very early stages. Then finally, in this phase, another key thing that we see is that the project team has to be aware of the contractual framework that they are working under. So if, for example, as was presented earlier, we find that in some contracts, let's say, for example, the FIDIC Red Book, we find that there are time limits for certain notices to be given for claims. And if a notice of such a claim is not given within the time that is required under the contract, the entitlement to that right is actually lost. So you see the consequence of even not following this simple contractual provisions in a contract is not just merely procedural, but it has a substantive legal consequence. And that could actually harm the claim of either an employer or even a contractor. So the entire project team must be aware from day one. What is my role in the contract? Then I want us to now go to phase 2. This is when now we have seen the early warning signs of the dispute, and now the dispute now is actually crystallizing, where we see now we have to actively manage the dispute. So we have in terms of what the project team should be doing at this stage is, of course, in terms of the documentation and the record keeping that we spoke about. Now we need to preserve this evidence immediately, because as we've said, it is clear that at this stage that the dispute might actually escalate to the formal dispute resolution mechanisms in the contract. So the project team now has to commence collecting all these relevant documents, that is the emails, the drawings, the photographs, the test results, the meeting notes, the site instructions, all those documentation, just to avoid any loss of that documentation and also to prevent any destruction of this evidence. And then also we find that at this stage is when most of the time the legal counsel or the legal team now is roped into the matter. And how the project team now, their role in this is that they should, of course, provide support to the legal team. That is helping the legal team with the data, the factual details, what happened, just to enable the legal team be able to advise advise the parties and also help them to review and build a strong case from the beginning. Then the final thing that the project team should be alive to do in this phase is a principle we call the mitigation of losses. So basically, this is a legal principle where a party is required to take reasonable steps to limit any further damage, so that even if the dispute is ongoing, continuing works, the works continue where possible, just to reduce the exposure to claims of prolongation cost and damages. Then finally, I want us to look at what happens, or what is the role of the project team now when the formal proceedings or the formal dispute resolution mechanism is invoked, of course, depending on the contractual framework. So in this stage, it is, of course, dependent on the contractual framework. So, for example, under the FIDIC, I'll take the FIDIC Red Book 2017, the dispute undergoes a multi-tiered process. So here you have the engineer's determination, you have the DAB or the DAB, then you have either arbitration or litigation. So, of course, each of these processes have their own rules and evidentiary requirements. But now we see that the project team's factual input is very important, because the project team at this stage now will be called upon to be witnesses, will be called upon to be subject matter experts. And so exactly what they know is very important, because they are there now to be able to clarify the factual issues and the technical issues. So preparation is normally very critical when the formal proceedings are now invoked, because the testimony must be consistent with the documentation that is available. And the project team must be thoroughly prepared and must know all the documents, and also the narrative to be presented must be supported by the documentation. And so coordination between the legal and the technical teams is very, very essential. So in conclusion, the biggest takeaway that you can get from this presentation is that when it comes to the project team, you must always remember that the dispute does not start at the point when the formal mechanism is invoked. The dispute starts on site, that is on the daily actions of the project team. So we keep on telling our clients, or we keep on telling the who we advise, we tell them document, because record management is the key to a faster and more efficient resolution of a dispute. And it is actually the difference between a dispute that is resolved quickly and one that drains time, money, and trust. Thank you. Over to you, Clive.
Great. Thank you very much, Christine. I mean, to reiterate, there's no difference from that perspective in disputes from Kenya and South Africa, is that record keeping during the project and retaining those records for a period of time thereafter in the event that any disputes arise is pivotal to any construction dispute. Clients moan at us many times that it's a very document-intensive process, any litigation on construction, and it is. So making sure your professional team are maintaining those records so that they're available for the parties, in particular if you're an employer, for the employer to litigate, for the contractor to make sure you can prove your claim, becomes vital. So thank you very much for that, Christine. There have been a few questions, and I'll try and quickly go through the questions. From the point of view of the next webinars, we're always, as a firm, happy to conduct webinars, and there has been one on health and safety and environment in Kenya. I'll chat to my Kenyan colleagues and see if we can put a webinar specifically on that particular issue. Over to your questions. Thank you for your questions. I have on the first question, which was a comment if the designer architect can be a principal agent, or would this be a conflict of interest? I prefer a situation where my principal agent is not the designer and the design architect, from the simple reason that it is the principal agent's responsibility to make sure the professionals are doing what they have to do. So if there's issues that come up with the architect and the architect's design, it sometimes difficult for the architect to then make a decision on that person's design, whereas the principal agent, being neutral to having designed anything, or either an engineer or architect, is more in a position to be able to say, this is what you have to do, this is where you went wrong. So on that, that would be my sort of takeaway. As for the principal agent in the JBCC resolving disputes as the engineer, as we know in the JBCC, the principal agent is entitled to adjust the contract price and the extension of time under certain parameters. It's a similar function which is taken by the engineering FIDIC in terms of 2017 edition. What's it, it was 3.5 in the sort of 1999 edition. So as opposed to making a formal determination as the FIDIC engineer does, there is an adjustment that's made by the principal agent in the JBCC where they don't actually resolve the dispute, but they set up and give extensions of time, etc., to the to a contractor. So it's not the norm that the principal agent would then actually resolve the dispute themselves. That's referred to amicable process through to the adjudication, mediation, and/or arbitration. But thank you for the questions, Ola. So yes, that brings us to an end. Thank you very much to our associates and senior associates for putting together their presentations and the guidance provided. I think everybody, for sort of being through it, would have learned something today and opened up those further questions that you might have. You've now met the team, and you've met our associates, or most of our senior associates, associate presented this morning. So if you've got questions and issues that come up, please, by all means, approach the construction engineering sector here at CDH, and that we can help you. Just a reminder that we have offices in Cape Town, Stellenbosch, Windhoek, Nairobi, and in Johannesburg. And the team, some of them that you met today, and the director teams are spread through those various jurisdictions. So we're able to give hands-on advice in those jurisdictions and are available to assist with matters and projects and issues, essentially through the whole of Southern Africa and up into Central and into East Africa as well. So thank you very much for the time. Appreciate it, and appreciate coming on to the webinar and taking up an hour or so of your time this morning. And once again, congratulations to the CDH team. And hopefully you'll all be on our mailing list for the next webinar. If you've got any views of what you would like us to talk about as well, more than happy to engage with our clients on topics to make it interesting, so that you as the audience are getting the most out of our webinars. So once again, thank you very much. Great. Thank you, everybody. Have a good day.
Thank you. Bye-bye.
Thank you. Cheers.
Thank you. Bye.
Bye.